All right. Let's begin. Hello, everyone. My name is Stanislav Stanskikh. I'm research fellow at UNC Chapel Hill and a visiting scholar at the University of Wisconsin Law School in Madison. I'm happy to organize and moderate these two wonderful roundtables on current Russia's constitutional development. This roundtable is the first one, and the second one will be held on Saturday, upcoming Saturday on November 7th at 8 a.m. in the morning, a little bit early. Everyone is more than welcome to attend. This year we have an unusual virtual format for the conference with over 2,000 participants. Despite some technical difficulties, I'm glad to see so many of you. So the roundtable will be recorded and might be available for members only within 1 year. After brief presentations, we're going to have a discussion and Q&A session. You can submit any comments and questions during the presentations or after them in the chat box down below. You can see the chat. I encourage our speakers to check the chat box periodically. So speakers can interrupt each other with clarifying questions or comments. If someone from the audience wants to speak with a comment or a question, please raise your hand or shoot me a message in the chat box. Okay, let me introduce our wonderful speakers. 1 second, I'll check if everything. Yeah, no one waiting in. Yeah. Okay, let me introduce our speakers. Coincidentally, all of them, including myself, were graduated from Lomonosov Moscow State University. It's our alma mater. So, okay, so I'll go with some brief introduction. Please correct me if I miss something. Something important in your bias. I'll start with Ekaterina Mishina. Ekaterina is an outstanding Russian constitutional scholar living in the United States. Most recently, Ekaterina served, among others, as a visiting professor of law and political science at the University of Michigan. Among other positions, Ekaterina was a senior clerk at the Russian Constitutional Court, serving to the Chief Justice Vladimir Tumanov in 1995-1997. I will put some links with full bios in the chat box for convenience. Okay. This is my bio and Ekaterina. Okay, I'll just text. 1 second. Okay, here we go. So you can find the full bios of all of our participants or most of them in the chat box. You can see those links. Kirill Rogov. Kirill Rogov is a prominent Russian political analyst. Among others, Kirill serves as a currently serves as a vice president of the Liberal Mission Foundation, a Russian think tank. Another participant, Andrei Kolesnikov, a brilliant expert and journalist. And Andrei is a senior fellow and the chair of the Russian Domestic Politics and Political Institutions program at the Carnegie Moscow Center. And Ilya Ponomarev is a famous Russian politician in exile, a former member of the State Duma. Ilya was among others, Ilya was the only member of the Russian parliament who voted against the annexation of Crimea. Feel free to correct or add something when you have a chance. So a lot of things happened since last January when these roundtables were submitted. Amendments to the Constitution, COVID-19, the All Russia vote and related constitutional rights violations, poisoning of the Russian opposition leader Alexei Navalny, Khabarovsk, new developments in post-Soviet space, Belarus, Kyrgyzstan, and many more. So, but for all of our speakers, the topic of the future of the rule of law in Russia is quite personal. So one of our initial participants, Vitaly Shklarov, he was detained in Belarus, and the association, our association, issued a statement on his detention. I'll provide a link to this statement. All right. So unfortunately, fortunately, finally, because of the U.S. State Department efforts, he is in the United States now. Just a few days ago, the U.S. negotiated with Lukashenko his release, and they let him go. But unfortunately, he is not with us right now. Another participant is Yulia Galyamina. She is with us right now. Mostly she's scheduled to speak for Saturday session. She's under right now criminal investigation because of her public political position about current constitutional amendments in Russia. I am a Russian constitutional scholar in exile and in political immigration. Ilya Ponomarev, a prominent Russian politician in exile, and currently he lives in Ukraine right now. And Ekaterina Mishina and Kirill Rogov played played an important role in protests of intellectuals this year against amendments to the Constitution and the procedure of their adoption. So for most of us, or for all of us, this topic is quite personal for different reasons. It's not only the subject of academic theory or something like that. And the last thing I want to bring your attention is a few words about the current today's discussion. So post-Soviet transformations in Russia were accompanied by constitutional reform, as you know, which culminated in the adoption of the 1993 Constitution. However, over the years, the Constitution has not fulfilled the hopes and failed to protect society from authoritarianism. This roundtable brings legal scholars and political scientists to discuss different aspects of contemporary Russian constitutional and political development. The speakers will explain the legal foundation of the political order in Russia by addressing some of the following questions. What are the birth traumas of the Russian Constitution? Why has the Russian Constitutional Court been unable to protect society from authoritarianism? How is Russia ended up with current authoritarian reality, let's say? What is the role of legal institution in Russian politics? What are the long-term effects of Putin's constitutional changes? I would say anti-constitutional changes. What are the prospects and pathways to the rule of law in Russia? Is there any light at the end of this kind of rule of law constitutional tunnel? So please, let's start with Ekaterina Mishina. Please unmute yourself. And I encourage everyone from the audience to tweet on Twitter and other social media about our roundtable. Thank you.
Thank you so much, Stas. Hello, everyone. Many thanks for joining us for today's discussion of the anti-constitutional amendments made to the Russian Constitution in the current year. I would like to start with a small follow-up to what Stanislav just said about the initial incapability of the Russian Constitution to protect the fundamental rights and freedoms of the Russian citizens. And in my book, the main reason for that was the initial huge disbalance of powers, which was envisaged in the Constitution from the very beginning. And I would mainly focus on the separation of powers, how it was established initially in 1993, what's so untypical, or I would rather say unusual, in the Russian design of separation of powers. And then I will proceed to the changes made in this system in the current year. So comparing to Western democracies, separation of powers has a rather short history in Russia. So for the first time, it was envisaged on the constitutional level only in 1992. In April of that year, the RSFSR Constitution of 1978 was amended and the principle of separation of powers was established on the constitutional level. Before that, for the first time, this principle was mentioned in a document of constitutional importance in 1990, when the Declaration of the State Sovereignty of the Russia proclaimed the separation of powers of legislative, executive, and judicial branches is the most important principle of existence of Russia as a legal state. So what's so strange about the system of separated powers, how it was initially envisaged in the Russian Constitution? If we look at the text of the Constitution, we would first see Article 10, which states that the power in Russia is divided into legislative, executive, and judicial branches. And interestingly, the president is not even mentioned. But if we switch to the very next article, we'll see that the list of bodies of state power starts with the president. So many critics of the Russian fundamental law pointed out that there is a huge disbalance between the three branches of power on one side and the president on the other side, because initially the president was not a part of the system of separated powers. He was placed as sort of above the system, and even more, Article 80, Part 3 established that the president determines the guidelines of domestic and foreign policy, which, due to the legal positions of the Constitutional Court, are binding for all governmental bodies, state officials, and citizens. What does it mean? That the president, who is not a part of the system of separated powers, can strongly affect operation and status of all three branches. And I would like to point out that the issue of separated powers is not purely theoretical. This issue was heatedly debated within the last 4 years on the appellate stage of the case of the Yukos shareholders versus Russia. And during this stage, the experts of the Russian Federation insisted that constitutional entrenchment of separation of powers in Russia is limited to Article 10, which doesn't mention the president. And they made a point that the Russian president is not like really power. Moreover, they repeatedly stated that his activities are strongly controlled by the parliament. However, the experts failed to prove this statement in court. But to make this dream true, the drafters of the constitutional amendments made the president even more powerful and strong and influential than he was in the initial constitutional design. So how exactly the amendments strengthened the presidential power? First, now the president can remove the chairman of the government from the office at his sole discretion. No confirmation of the Duma or consultations with the upper chamber of the parliament are needed. Also, now the president conducts the general leadership of the government of the Russian Federation, which means that now the executive branch is subordinated to the president. Also, he directly appoints a group of the most important ministers, members of the government, namely those who are in charge of the matters of defense, state security, internal affairs, domestic international affairs, justice, and others. He appoints these ministers after the non-binding consultations with the Federation councils. And what's even more important, he can dismiss them also at his sole discretion. So these constitutional amendments actually bring the constitution in line with reality, because the role of the president in the executive branch was escalating in the span of the last 2 decades. So now the reality is envisaged on the constitutional level. Also, I would like to make a point that now the president takes a very active part in formation of the Federation Council, because he appoints 30 members of the upper house of the Russian federal legislature. And what's even more important, he can appoint 7 of them for a lifetime. I would like to make a special point on the role of the president in judicial appointments and dismissals as it looks now. Now, unfortunately, the judicial branch completely depends on one person, and this person is the president of the Russian Federation. Even before the amendments were submitted to the Duma and came into force on July 4th of this year, the president had a final say in all judicial appointments. Now he can initiate termination of powers of most judges in the Russian Federation, starting with the Chief Justice of the Constitutional Court and Chief Justice of the Supreme Court, members of both courts, and also judges of the cassation courts and appellation courts. No involvement of the bodies of judicial community is envisaged. And what's even more important, the reason for such termination of judicial powers under the request of the president, which is supposed to be submitted to the Federation Council, is really vague, because violation of the standards of judicial behavior is a very flexible definition, which automatically creates unlimited possibilities for the abuse of power. And sadly, I must state that now the Constitutional Court is becoming a pocket court for the president of the Russian Federation. First, the court has been downsized from 19 justices to just 11 justices, which means the enormous amount of work which these justices will have, and they will be totally under the president's thumb, because, as I just mentioned, their positions are not secure anymore. These constitutional amendments completely killed what has been left from the judicial independence and irremovability of justice judges in the Russian Federation. I don't want to abuse your time, and in case you have questions, I will be really happy to answer them. Thank you.
Thank you so much, Ekaterina. Any brief questions or comments among our speakers? If not, we will Kirill? No? Okay, Andrei, your turn. The floor is yours.
Thank you so much for this opportunity. My approach would be a little bit more political than legal, if we compare it to Ekaterina's report, despite the fact that we have graduated accidentally from the same academic course in the Moscow State University. It was many years ago. I'll begin a little bit afar. I'll try to contribute some historical approaches to the problem. Constitutions are changed when something seriously moves in the state and society itself. Hence, the wave of new basic laws in post-war Europe. For example, the 1946 Constitution of France. Then, at a time when many countries were getting rid of dictatorships in 1970s, the time for constitutional creation also came, for example, in Spain in 1978 and in Greece in 1975. The Soviet Constitution of 1936 consolidated the formation of Stalinist totalitarianism, and it played the same role as Stalinist architecture to be a lush decorative facade of the regime. But again, we are talking about such quality of the basic laws as fixing the changes, political changes primarily, and economic ones. The same story with Brezhnev Constitution, which was first to be Khrushchev's, its first version was written in 1963. Khrushchev wanted to record the results of his rule, but only Brezhnev managed to perform this trick in 1977. The Yeltsin Constitution of 1993 also recorded the changes and the results of the bourgeois revolution. The 1993 Constitution was strictly according to Lenin's formula, a reflection of the real correlation or balance of forces in the class struggle. I have to remind that it was a result of a bloody civil war episode. At the same time, this constitution became also the constructor of reality of the Russian statehood. However, reality turned out to be stronger and tougher than the constitution. And the fact that this was the basis of the presidential republic did not imply, in my opinion, that the political system would inevitably tilt in the authoritarian direction. The constitution was not to blame for that. To those who insist frequently that imitation institutions borrowed from the West do not work, I would like to remind that Russia had a real parliament just after 1993, with which the president and the government were considered. And there were real elections, and the people were absolutely ready for democracy and used it, including chapter 2 of the Constitution on human and civil rights and freedoms. It was the authoritarian power that turned the Constitution into a decoration. It was the politicized Constitutional Court, whose chairman, Valery Zorkin's ideology coincided with that of autocrat Putin, that contributed to the quasi-legal cover-up of Russia's transformation into an authoritarian state. Authorities ignore the fact that constitution is an act of a direct action, and for instance, Article 31 on the right of to free assembly is also applied directly, and the highest act in the hierarchy of laws. This is one of the constitutional rights that are most often violated. The birth traumas of Russian democracy and the presidential bias of the constitution have nothing to do with how the Putin regime evolved and how it ignored the Yeltsin constitution. At the end of the day, the moment has come when Putin has decided to record the changes that have taken place in the political and economic system for 20 years of his permanent rule. At the same time, he brought clarity to the prospects of his own career. And the notorious zeroing of terms was the abolition of the fundamental constitutional principle of power rotation. Amendments to the constitution also fixed the ideological framework of Putin's state that had entered the maturity stage. As a result, within the formal framework of one constitution, we have two basic laws, Yeltsin's and Putin's. Yeltsin's remains a decoration, Putin's in its basic provisions is applied in practice. Among ordinary Russian citizens, there is a widespread belief, and this is not a joke, but the result of sociological focus groups, including recent focus groups, which we have made with the Levada Center, that the 1993 Constitution was written in the USA. And now it is time to gain sovereignty and a sovereign constitution. For this reason, the masses will not start reading it anyway. They never read Constitution, but now they sleep quietly. Not only Crimea, but also the Constitution is ours, the Russian one. One more problem. The slogan of the political opposition last summer could have been protection of the 1993 Constitution. It would also be, could be a continuation of the tradition of the Soviet dissident movement with its slogan, comply with the Soviet Constitution. Maybe you remember that it was the slogan of 1965. But unfortunately, the opposition did not take the basic law seriously either, and therefore simply ignored the abuse of the constitutional foundation of the Russian state. The famous Russian classic of 19th century, Mikhail Saltykov's dilemma, either you have the constitution or you have sturgeon with the horseradish, such a symbol of plenty Russian style, is still with us. But the first element, democratic constitution, is a condition of the other element, economic wealth and common good. And the absence of the first element leads to the result that there is no democracy and no valuable fish on the table of the majority of Russians. So maybe I will stop myself here. Maybe it's enough for the introduction.
Thank you so much, Andrei. A quick question. What did you mean by saying that opposition simply ignored this comply with this slogan? We have this campaign. We had in this year quite a few campaigns, a few petition campaigns. Campaign Нет, and Yulia Galyamina, she is one of the bright representative of this campaign. So what you mean? You meant Alexei Navalny, his unclear position about this, or by opposition? What you meant? Unmute, please.
I meant that the planned capacity of this movement Net was not enough to change anything in this situation. Unfortunately, maybe it was an objective story, and I can't blame anyone because I'm also the part of civil society. But at the same time, it was a good reason for use for using it in not in a political struggle maybe, but in terms of reawakening of civil society on this very ground. But it means that constitution is not so significant for the public opinion in Russia as well, not only for the elites, not only for the establishment who simply violated law, abused law, and so on and so forth. This is also insignificant for big masses of small majorities, liberal majorities who are against Putin's regime. This is not the ground for consolidation of the opposition or even civil society. This is not ground for visible, noticeable protest mass movements. So in that sense, constitution somewhere is marginalized, like this.
Thank you. Kirill?
Thank you very much. So what I want to start with, in early 1990s, a lot of countries experienced a sort of liberalization or transition to electoral regimes. We usually are usually focused on two group of countries, post-Soviet ones and East Europeans. But actually, there is a third large group of countries in sub-Saharan Africa. And if you look now, after 25 years, on the results of this liberalization, what can we see? The East European countries, they were in the orbit of influence of Europe, and their constitutional design shifted to parliamentary republic. All the rest, in all the rest countries, we can find two large groups. With some exceptions, two large groups. The first one is a stable electoral regimes.
Kirill, excuse me, please. Sorry for interrupting. You told me that you planned to show us presentation. No, you decided.
I need not presentation.
Okay, all right,
So
fine. Okay.
There are two large groups. The first group, stable electoral semi-democracies, or maybe not democracies, but stable electoral regimes that are characterized by first, the original terms of presidency are preserved 4 or 5 years. The 2 terms limit rule works. A certain competitiveness of the president election remains. In the long run, the winner takes about 60% or something like that. Parliament remains competitive, and control over it of the incumbent's party is not stable. It's occasional. And opposition plays a huge role in parliament. The level of civil and political freedoms on the scale of Freedom House is between 3.5 to 5. And there is a predisposition to parliamentarization in the design, in constitutional design of those countries. The other group, quite the opposite, is characterized. Presidential terms are usually increased to 6 or 7 years. Presidential elections are not competitive. The winner, in the long run, we see the winner takes 75, 80, 85%. The 2 terms limit is lifted on some excuse. The level of civil and political rights is between 5.5 to 7 points on Freedom House scale. And in constitutional design, we see the transition to super presidentialism. The concept, we see the concept of president supremacy. Katya mentioned what it is to some extent. It's the idea that president power, president branch, president authority is above the other branches of power. The main question is what the fundamental cause of this divergence? Was it that the initial constitutional design or the dynamics of political competition? What we see if we look at post-Soviet countries. For example, Georgia and Armenia initially adopted presidential constitutions following more or less American model. The level of presidentialism was very high there, and we could expect their move towards super presidentialism. But in fact, both countries are almost parliamentary republics now. From the very beginning, the attributes of super presidentialism could be detected in constitutions of Azerbaijan, Uzbekistan, and Turkmenistan. Other countries adopted predominantly semi-presidential constitutions, but the particular modes of how the power is shared between parliament and president differs there. Surprisingly, in Kazakhstan, Kyrgyzstan, and Belarus, we see initially very pro-parliamentary constitutions. But in the mid-1990s, the conflict between the parliament and the president was resolved in favor of the latter, and the constitutions shifted towards super presidentialism. However, in Kyrgyzstan, after the revolutions of 2005-2009, the constitutional model was shifted again towards parliamentarism. In Ukraine, the constitution was initially more parliamentary, but during Kuchma's presidency, the president power was substantially extended and became very high. However, when Kuchma failed to either stay for third term or to put his successor into the office, the presidential power was sharply reduced under the agreement concluded during the Orange Revolution. Those examples demonstrate that there is a sort of interconnection and interdependence of the level of political competition and the evolution of constitutional model. From the outset, the Russian constitution contained the evil grain of pseudo-presidentialism. It was pseudo-semi-presidential. On the one hand, the president had significant leverages to control the government, and the parliamentary vote of no confidence in the government did not work automatically, and the final decision remained with the president. Those traits are typical for presidential constitutions. But presidential constitutions usually do not suppose the authority of president to dissolve the parliament. Thus, the president power combined the advantages that gives to president both the presidential model and semi-presidential model. However, that does not mean that the evolution of political regime was predominated by this constitution. In 1998, amid the crisis and because of the president's low popularity, Yeltsin was forced to form the government of the parliamentary majority, which opposed to him. And for 6 months, there was a classic semi-presidentialism on the French model in Russia. And only when in 2000s, a sharp decline in political competition occurred and the presidential office began to steadily control parliament, the prerequisites for the realization of super-presidential model arose in Russia. So there is another poison pill of super-presidentialism in 1993 constitution. It is the phrase that the president shall ensure the coordinated functioning and interaction of state government bodies. This phrase also elevated the presidency above other authorities and beyond the principle of separation of power. But the same phrase we can find in the first constitution of Armenia. However, the actual implementation of this potential of super-presidentialism started when political competition was curtailed and the president's actual control over parliament was complete. All this was not so much the result of the 1993 constitution, but of the diminution of the de facto power of federal parliament and regional parliaments. Now, constitutional amendments reflects the consolidation and further development of this logic of presidential supremacy. It is finally enshrined in the innovative concept of public power introduced by the 2020 amendments. This concept unites all branches of government as well as local government into a single mechanism dominated by president supremacy. And my last point is, we usually define such regimes as personalistic, and we assume by default that personalistic is mostly about some person, strongman and so on, someone who accumulates all the power in his hands. But the analysis demonstrates that personalism here is highly institutionalized and even constitutionalized in the specific constitutional model. So actually we deal with a definite and sustainable political order that is supported with particular non-democratic constitutional design. In its turn, this means that durability and sustainability of such regime not so much depends on concrete person as we usually suppose. When leaders of Turkmenistan and Uzbekistan died in office, they were substituted by new figures in a couple of days, and nothing had happened or changed in the regime functioning. So the idea is that while personalism is institutionalized and constitutionalized, it meets expectations of elite groups and people, and personalism here is more institutional characteristic than the effect of a particular person. And if so, there are much more opportunities for successful transition of such authoritarian regime from one person to another than we used to think. Thank you.
Thank you so much, Kirill. Any comments?
I have a small comment, if it's okay.
Sure.
Kirill,
Yeah,
thank you very
absolutely.
much for the beautiful presentation. I just want to make a very small non-constitutional amendment to what you have just said, because there is a well-known statement that the Russian constitution in its initial version was modeled on the Constitution of the Fifth Republic of France. I would like to highlight the main difference between these two constitutional designs. And this is the role of the government, because in France, the Constitution of the Fifth Republic is based on 5 fundamental principles, which were envisaged in the law of June 3 of 1958. And one of these fundamental principles is that the government is responsible before the parliament. In Russia, things work in a completely different way. From the very beginning, the government was responsible before the president. Now it's completely subordinated to the president. So the role of the chairman of the government is close to zero. So this zeroing affected not only the presidential terms, but also the status and the scope of powers of the person who used to be the head of the executive branch and whose status is now, for me, as a constitutional lawyer, pretty much unclear, because the amendments put Putin directly on the top of the executive branch, and at the same time, he retains a very important leverage, the power to dissolve the lower chamber of the House. So there is a fundamental difference between the French Constitution and the Russian Constitution in the role of the government and the way the government is responsible before another branch of power. And definitely in Russia, the role of the government is not as important as it is in the Constitution of the French Fifth Republic. Thank you.
Yes, thank you very much. I agree. And I mentioned that the main problem of the Constitution of 1993 was that the final decision on the government retirement and on dissolving of parliament, they both had the president. So it's not semi-presidential model. So it's pseudo semi-presidential, and that was this poison pillar. Yes. But my point was that instead of that, under the pressure of political competition, that could work like French model in some situations when the opposition was very strong. But while the president became strong, it became super presidential.
That's absolutely correct. I agree.
Thank you.
Okay, any other comments or questions? Andrei, Peter Solomon
I
today
can simultaneously
with us.
answer the question which is in the chat.
Okay.
Would you agree that the first abuse of 1993 Constitution took place during 1996 presidential elections? Again, we must take into account, in my opinion, historical circumstances of the birth of this Constitution. It was born in the fire of civil war, real civil war with victims. It was a result of it. And because of that, this Constitution was more presidential than the previous variant, which also has been prepared by Constitutional Commission before 1993. At the very beginning of the Russian Federation, without any kind of normal constitution, I mean the year 1999, in the circumstances of the disruption of the Soviet Union, I must remind that Yeltsin combined the positions of the president and the prime minister for several months until the summer of 1992. He had to do it because there was no time for some delicacies, for some details, for some legal contributions to this kind of activity. I mean, modernization and liberal reforms. So it was a very unusual situation, unprecedented historical situation in that sense. If you want, it was the first birth trauma of this constitution, not the story of the Soviet Union, but the story of the first years of an EU state without constitution, without even, I don't know, normal parliamentary governmental bodies and so on and so forth. It was a problem. In that sense, we had very tough reality. To some extent, answering this question, I would say that yes, maybe it was the first abuse of the constitution, but also the normal consequence of this constitution, the implication of the super-presidential essence of the basic law. But again, in my opinion, real circumstances were much more important than the legal fundamentals of this constitution or any other law in these circumstances. Not to mention that 1996 elections were more or less just and more or less free, if we compare it with any other elections after that. So in that sense, again, it seems to me that reality is much more difficult that we can imagine, and when we are trying to implement only legal approach to the current new Russian history, post-Soviet Russian history.
Thank you so much. Ilya Ponomarev, please. Are you with us? Yeah, I see.
Yes. Hello, everyone. And
where are you?
Stas, I'm in Washington, D.C., actually.
Okay.
So, and Stas, thank you very much for letting me participate in this distinguished panel. I think the subject that we are discussing is one of the most important ones in Russian politics in general, and to analyze where we are and how we got to this point where we are with the constitution, I think is extremely important to avoid the mistakes of the past in our future, no matter when this future would finally come to Russia. And I would actually try to spice things up a little bit, and I'll pick up where Andrei has just stopped. And I would propose a slightly different answer for the same question, you know, when did the abuse start? And to my mind, this whole constitution is the child of an abuse, is the child of rape of Russian democracy, which happened in 1993. And in politics, as Andrei absolutely correctly said, is not all about laws. It's not only about the legal aspect. It's about the political tradition. And the political tradition of Russian Federation actually started in 1993, because that's where the current the modern Russian statehood was actually born. And I would like to remind about several events, several things that happened during the adoption of this constitution. Of course, everybody knows about the decree 1400, which disbanded the parliament and the shooting of the tanks. That's what everybody knows. Not many people actually realize that what we had before this decree was a parliamentary republic. Soviet system was a parliamentary system, and even at the time of rule of the Communist Party and its special role, which was actually a part of the Brezhnev constitution, which was later taken out, I believe, in 1990 by the Soviet parliament of that time. But still, even the rule of the Communist Party was a collective rule, because even Communist Party was directed through a Politburo, a collective organ, and not a unilateral power of one person. So it was a fundamental change which happened in 1993. In a certain degree, it was a return to monarchy. And the way how it happened actually reminds us very much of what President Putin has done this year. All the tradition actually was started in 1993. It was not Putin's invention. The constitution was adopted not on a referendum, but on public voting, exactly the way how Putin has done it in 2020. I remind that our beloved reputable, respectable among liberal circles, mayor of St. Petersburg, Anatoly Sobchak, who played one of key roles in adoption of this constitution, actually petitioned Central Election Commission in November 1993 to ensure that there would be a prohibition of campaigning against the constitution, and it was explicitly prohibited by the Central Election Committee of that time to campaign against the constitution. You could not do this in the democratic Russia of that time. And despite that, the constitution failed in approximately 1/3 of Russian regions. The level of support of the constitution in central Russia in average was around 40%. Tatarstan, one of, as we all understand, key elements of the current federation, is one of, if not the most influential national republic, boycotted the constitutional process and did not take part in the voting on the constitution. Several of the North Caucasus republics totally failed the constitution. For example, in Republic of Dagestan, this constitution got only 20% of support. And if you also look at the numbers of turnout, you would see the difference between turnout for the general elections, which was taken there at that time in the parliamentary elections, and the turnout on the constitution, which actually means that the results on the constitutions were, I would say, adjusted by certain governors who received that orders from Kremlin. And at the end of the day, what we see with this constitution is that somebody who wrote it actually confused rule of democracy with rule of Democrats. And that's what we finally have. In the 90s, it was in a certain way balanced with the personality of Boris Yeltsin, who of course was a pretty authoritarian ruler himself, but he has certain ideals on the freedom of speech and the way how he understood democracy, and that was, in a way, he was the main check and balance within that constitution. As soon as he was gone, there are no more checks and balances. And I would say if during Yeltsin time we were facing super presidential, but presidential as an institution, president's republic, in Putin's time, there is no longer even such institution as presidency. And that was brilliantly proven during period of 2008 to 2012, when we had the presidency of Dmitry Medvedev, but the actual power stayed with Vladimir Putin, which is pretty obvious. That means that we cannot describe modern day Russia as a presidential republic. We currently can describe modern day Russia as a Bonapartist republic, where the power stays with Vladimir Putin, no matter how his position would be called. And this, what I think is the most important lesson that we need to digest. And to my mind, the main lesson of this constitution, of course, that it would require to be rewritten completely, and it's not an amendments process, but it's a rewriting process that we need to do after the change of the current regime in Russia. But we also should understand that the people who actually write the document should be totally separated from the future power in the country, because if they will not, we will once again get the document which is tainted and driven in favor of a certain group of power that would carry on. And to conclude, I would say that I told about all the bad news. There is also some good news. I think that we have on the post-Soviet space examples where the constitutional process was successful, and where the constitution was written in the way that prevented at least monopolization of power by a certain group. in different ways. Not all those countries are successful because, for example, there was a successful transitional process in Kyrgyzstan, and we know that people of Kyrgyzstan are not completely satisfied with what is happening in Kyrgyzstan, but at least there is transition of power in this republic, and no monopolization of power can take place. And I think this is the lesson that we should all learn. Thank you.
Thank you so much, Ilya. I would like to ask, if it's possible, each participant to answer one more question. Your personal opinion, expert opinion, how you want to take it. So this year, Vladimir Putin initiated these amendments, and we know kind of why, and we know the outcome and so on. But my question is, why was Putin in such a hurry and such a rush to initiate those amendments this year? Why it happened this year, not next year, not 2021, not 2022? He felt some kind of threats, internal threats, or what was the, in your opinion, what was the major reason why he was in such a hurry? It's a question for everyone, if possible. Just your thoughts would be appreciated.
How we do it, one by one? You know,
oh, just yeah, just yeah, feel free. Democracy.
Okay, so let me start, and if I raise my voice. So, to my mind, Vladimir Putin didn't need those amendments. I think that they were mainly motivated by the political reason. Firstly, they are the strong message to the political elite that he is no lame duck, that he doesn't want to go, and that he would not go. But it doesn't mean that he would not go by staying Russian president for another, de facto sixth term in 2024. To my mind, the most possible transition scenario still would be a union state between Russia and Belarus, and him ascending to the position of the leader, the great chief, the beloved ruler, whatever, of the combined state. But he needs to make sure, firstly, that he has the option to stay as the president of Russia, and so that nobody has any illusions that he can continue to carry on as a Russian president if that would be necessary. Secondly, still, I don't think that the elites would be really happy if he would stay as the president of Russia for another term, because they are getting tired. And a lot of the amendments that are being passed and already passed through the Russian parliament so far, they are targeted to tighten the control over the elites so that nobody can raise their voice. And I think that's the main reason.
But do you have any explanation why it happened this year, not at the end of 2020, not in 2021?
No, just the sooner the better. Just the sooner the better. There's no illusions and more flexibility, more space for maneuver in the future.
Okay, Kirill, do you have any?
Actually, in any year it would happen. You could ask this question: why in 2021, in 2022?
Okay.
Of course, you should avoid a lame duck effect as soon as possible, and the situation in economy is not good, and there is a decrease in popularity. So it's reasonable. And I want only to add that it seems that from the second day after the president elections in 2018, Vladimir Putin started to work on this problem, trying to solve the problem. And the first story was about Belarus and some making a new state. Maybe in the beginning of this year, it was obvious, maybe in that moment in January, that COVID-19 would be the main story of the year, and maybe he decided that it's better to do it now, to make it as soon as possible. So, but I
have some legal kind of guess or possible explanation to that. Let's say if they planned or started to plan this kind of amendments last year in 2019, back then they wasn't sure they didn't have like a clear picture, clear plan of this so-called constitutional reform, and we saw it how amendments changed in January and February and so on and so forth. So, but maybe they kept in their mind a possibility to hold a referendum on those constitutional amendments, but federal constitutional law on referendum prohibits conduct referendum 1 year holding the legislation prohibits holding a referendum in the last year of the term of the State Duma and during national election season. So basically they had this window. They should, if we're thinking about possible referendum, they should conduct that referendum before September, whatever, when next year, yeah.
I think you're mistaken here, because you still continue to call this referendum. They didn't have a referendum.
No. I said that when they didn't have a clear plan last year, how to implement all of those amendments. Maybe
but they never wanted to have a referendum. It's not subject for the legislation on the referendums. What they had is public voting. It's not a referendum. That's exactly the same thing that was done in 1993.
Yeah. My point is
that's why they were not limited.
Maybe they hold this, I don't know, for some reason, because legislation prohibits to hold a referendum last year before parliamentary elections. So that's my legal explanation.
No, that legally they passed the amendments in the constitution during a regular parliamentary process. They didn't require any public voting at all. And
I'm trying to explain why they initiated this process so early at the beginning of this year, because they wasn't sure how they exactly want to implement those amendments. They didn't have this plan about this all Russia vote. The model itself of all Russia vote been creating during the process in January or February, and then they came up, Kalishas and other people, they came up with this model.
It just also take part in this very interesting discussion and add a little bit when you're done, Stanislav.
I'm done. Yeah, I'm just.
Oh, okay, thank you. So first of all, I just want to concur with Ilya on the point that it was not a referendum, and that could not be a referendum because the law on the referendum has very precise requirements, and in order to avoid unexpected complications, it was decided to create something which was completely non-existent in the Russian legislative framework until February 14th of 2020. And that was not a Valentine's gift to the Russian people. That was a completely different thing. That was a presidential decree which established that voting on approval, mind the language, voting on approval of the constitutional amendments must be taken in a form of the all Russia vote. And the Constitutional Court of the Russian Federation, and in its opinion of March 16th of 2020, underlined that yes, there was no such thing in Russian law like all Russia voting, but the constitutional lawmakers were eligible to use it for constitutional legitimization of constitutional amendments. And a little bit more information, which I think deserves mentioning. My version is that one of the amendments, which was in a package which was introduced by Putin on January 20th to the State Duma, has a very clear story. I mean, the new power of the Constitutional Court to decide on the possibility to enforce judgments of foreign courts, international courts, and foreign and international arbitrage courts if these judgments disagree with the Russian public order. That was done completely ad hoc because at that time Russia was anticipating the judgment of the Court of Appeal in The Hague, and definitely Russia didn't want to enforce it. So initially, Russia pushed the idea of introducing a legal possibility to avoid enforcement of judgments of the European Court of Human Rights, which was first envisaged in the federal constitutional law, the Constitutional Court in 2015, and then it was elevated on the constitutional level in this year. But when the amendments were submitted to the State Duma, there was not even mentioning of this possibility to avoid enforcement of judgment of foreign courts if they disagree with the Russian public order, because it's not a category of Russian constitutional law. It belongs to a completely different area of Russian law. It's international private law, which means this category completely vague. And if something is weak, it disagrees with the principles of the legal state. And Russia is still a legal state. At least that's what we can find in the very beginning of the Russian constitution. So I think it's a very clear explanation why the possibility to push away the judgments of foreign courts and arbitrage in case they disagree with the Russian legal order was envisaged on the constitutional level because of the possibility of the Court of the Hague to deliver a judgment against the Russian Federation, and that actually happened.
Thank you so much. We have two questions to Andrei Kolesnikov again, and one question to all of you. Let's start with second question from Irina Khmelko. What influence Duma has on Russian political process, probably? Is it a rubber stamp to Putin, or does it have independent roles? Who would like to answer this question? In the chat box.
Maybe I take this as a former member of Duma. So
that would be.
It is a rubber stamp which plays an independent role in the system. So the correct answer is because obviously it's fully controlled, and it was fully controlled from 1994 when it was created, and we saw this many times. It was given a certain degree of independence by Boris Yeltsin, despite that even at that time executive branch monitored and controlled to a very significant degree the election process, and so already parliament was stripped of most important ways it could govern. Especially the possibility to develop the budget and to control the government and to run independent investigations and so on and so forth. but at least a certain level of discussion and political dialogue was allowed on that platform, and it was taking place, and sometimes pretty radically, as we know, because opposition was playing a significant role in Duma, never controlling role, but a significant role. During Putin's times already, it's not the case, but still Duma is being used as an instrument of internal checks and balances within the ruling circles, because Duma is allowed to criticize government. Duma is allowed to turn down certain pieces of legislation on which there is no consensus within the authorities themselves, but it should not dare to challenge the most critical and important decisions that executive branch wants to undertake.
Thank you so much. Andrei, could you please answer the question?
Yeah, if I may, can I shortly contribute to your question about the time of this decision in a short way? I would say that we all know that it was the decision of the president, the decision of Putin. It was a bit like improvisation, because it looked like the decision on Crimea annexation. Absolutely, it was unexpected. It was after the vacations, the beginning of the year. Maybe it was simply such a personal desire, but we also know that he is a man of a great intuition. And maybe he decided that this is a good time for political mobilization right now, this year, not knowing about COVID and possible falling of his ratings in spring. So he felt the need in mobilization, I think. It is always timely to create the infrastructure of transition period to contribute clearness to it, but at the same time, yes, really, why now? Why this year? So it was his feeling that he must do it right now, this year, before parliamentary elections. My idea was it's better to do after the parliamentary elections. Here is a time for clearness for the future. But he decided to do it before that.
So talking about mobilization that you just mentioned, can we say that Putin, one of his goals was to replace so-called Crimean consensus to new kind of consensus?
Yeah, Crimean effect, rather, Crimean impact on people, yes. And it's quite important that this year was the year of the 75th anniversary of the Great Victory. And this coincidence is quite good for this kind of public relations company. Mobilization of the ground of the support of the president, who is a successor and inheritor of the Great Victory. It looks like quite efficient in terms of political mobilization. About the current lack of personal importance of the constitution, I simply have found right now some sociological data. For instance, of the year 2019, 30% of respondents say that constitution does not play a significant role in the life of the country. Quite fresh data last year. So not so much people read the constitution. The data of 2018, the main law of the country has never been read by 42% of participants, of respondents of Levada Center poll. Only 9% stated that the constitution's content was familiar to them well. It means that people don't know their own constitution, they don't read it. This is simply one of the symbols of the state, not more. And at the very beginning of the year, this year, in January, after the decision of Putin, the majority, more than 50%, said that all the stuff is for the continuation of Putin's rule. despite that fact, people voted for it. We don't take into account right now the ratio of falsification and all this stuff. So they voted primarily, as sociologists say, because of some hopes to solve, first of all, socioeconomic problems. People believe that constitution can fit them. This is an instrument of the improving of the economic situation, paradoxically, because they don't know what for the constitution is. So here is the answer.
And yes, anyone would like to? Peter, please unmute yourself, or Peter, please unmute yourself.
Better. Now do you hear me?
Yes.
Okay. No, I've noticed over the past few months, in the period since the amendments were adopted, a trend that I find disturbing, and I wonder if others see this as a trend, and that is a kind of a discouragement of constitutional discourse, discussion of of constitutions. I mean, there are these two pretty blatant developments. One, the elimination of one of the leading cafedras of constitutional law in the country at Vyshka, and even firing of 4 of its professors. And then there's the thing that's going on right now, in the draft law on the Constitution in the Duma. Of course, as most of you know, there's a ban on the publication, distribution, discussion of dissents or concurring opinions, особые мнения, which of course are an important source of constitutional dialogue, ideas, criticism, and so on. The message seems to be that to discuss, not to speak of criticize, the Constitution is now a form of political dissent and can lead to consequences. Is that, at least that, I hope this is too pessimistic a conclusion, but I note in the discussion at the beginning, even before the session started, there were allusions to the fact that some of the participants in the panel had been critical of the Constitution, and there have been problems. So what do you think?
Peter, thank you so much for your comment. I would take it mostly as a comment rather than question.
As you like it.
It's hard to disagree. We all don't like what's going on with amendments and the procedure for their adoption. But I would like to ask Andrei Kolesnikov to just for a couple of minutes to tell us about you came up recently, just a few days ago, with some conception of new totalitarianism rather than authoritarianism. I saw it somewhere on the web. You published it somewhere. So yes, what Peter said. Peter, Russia is an authoritarian state, no doubt, right? So and we have this authoritarian trend, and it gets worse and worse. But Andrei came up with a different explanation from kind of political science point of view. What kind of trend do we have? How to describe this this conservative turn or something like neo-totalitarianism?
Yes, it was a bit speculative for sure, for the column, for the website of the New Times. But at the same time, I took for the beginning the idea of Zbigniew Brzezinski about the difference between authoritarian rule and totalitarian rule. So he said, he wrote in one of his works, that authoritarianism is primarily prohibitions, and totalitarianism it is also prescriptions to do something, not simply prohibitions. In that sense, any kind of prohibition, for instance, for members of the Constitutional Court to publish their opinions, this is a prescription at the same time. In that sense, this is a behavior of the totalitarian government, not simply authoritarian. This is not strictly a political science in that sense, but using these criteria, I would say we can find some signs of totalitarian thinking, totalitarian rule inside our mixed hybrid authoritarian system. It was the idea of prescriptions to do something for people who are responsible for important areas, just like members of the Constitutional Court. If we'll take the topic of our roundtable discussion right now.
Thank you so much. Anyone else? Any questions, comments so far? We have 5 minutes. Okay, if no one wanna say something, we have Maria Snegovaya. Are you with us? I see you among participants, not sure. Okay, so I would like to pay your attention to a few campaigns that happened recently in Russia against those so-called constitutional amendments. And I just give you an example. The most successful petition campaign that I ran with Yuri Jibladze, a Russian human rights defender, and many of you were among initial signatures of that campaign. That petition gained 250,000 signatures of Russian citizens on change.org. It's the most, that's it. We even didn't get it partially because many political leaders such as Navalny or Khodorkovsky or some other people, but mostly because Navalny had a different kind of different strategy about these constitutional amendments. And so that petition was, we asked Council of Europe to request legal expertise of Venice Commission, expertise on those amendments to the Constitution and the procedure for their adoption. And because of that petition, Council of Europe requested such an expertise. And in basically till the end of the year, we are waiting for the first preliminary expert opinions from Venice Commission regarding this matter. And it gives us not a hope, but at least it's going to be something. It's going to be something, and yeah, just mostly for information and also to show how little support among within Russian society had those protests against the reform, nullification, and so on. Yeah. Anyway, we have 4 minutes.
No,
So,
Stas,
yeah,
I think that you have raised. I think that you have raised an important thing: is whether the campaign to defend the constitution in June could it have been successful in general, and was it possible to generate grassroots support for that campaign? And actually, my observation is that it was absolutely feasible. And I believe it was not only my observation, but also Kremlin's observation, because they have done everything to falsify the results of this voting, that they have created that even some election commissions, like the election commission in my region in Novosibirsk, actually declined to participate in this voting. And that's kind of, it's a part of official system of power, but they said that they would not take part in the procedure that they don't see as illegal, because it was not a referendum, as I said before. So I think that the campaign could have been successful, but again, it was sacrificed for the personal ambitions of different representatives of Russian opposition, who were thinking in different directions. And certain people, they wanted to campaign, certain people, they didn't want to campaign. And as the result, we failed the process of mass mobilization against those amendments. And I think it could have been extremely important. And we saw other examples in different countries in the world where such campaigns were successful, even in the situation of authoritarian rule. We all remember, and there was a lot of articles written about the example of Pinochet in Chile, but not so many people wrote about another example of a referendum that Hugo Chavez actually organized in Venezuela to prolong his terms in power. And despite that he was a genuinely popular leader at that time, he failed that referendum because people said, okay, so we voted for you, but it doesn't mean that we wanted to stay in power forever. And that actually gives us a lot of ideas that such campaign in Russia could also have been very successful, and Kremlin was afraid of the success of such campaign and mobilized all his connections within the opposition to actually not to allow this campaign to happen.
Thank you so much. Any other comments, closing comments or questions? Maria, would you like to please unmute yourself, or I should unmute you? I don't, 1 second. No, I'm afraid, yeah, we run out of time. Thank you so much for this wonderful discussion. On Saturday, this Saturday on 8 a.m., we're gonna continue and discuss mostly trends and the plans of Russian political opposition, how they see this future constitutional design, what they're gonna do with the current amendments, what their strategy should be. And we will talk more about constitutional, anti-constitutional amendments, or this constitutional coup d'etat, what we have right now.
We will hit this up even more.
Absolutely, Ilya, absolutely. Thank you so much. Thank you.
Thank you.
Bye.